Hello, good evening. We, the members of the NRM Parliamentary Caucus, assembled today, Friday, 21st February 2025, at State House Entebbe to deliberate on matters of national importance, recalling our commitment to the continued leadership of the NRM in spearheading Uganda's socio-economic transformation and securing the strategic interest of our nation. Mindful of the recent Supreme Court ruling concerning the establishment and jurisdiction of the court-martial, and guided by the address of His Excellency the President on the same matter, acknowledging the need for legislative clarity and amendment or alignment of the Uganda People's Defense Forces Act with the decision of the Supreme Court of Uganda. Cognizant of the ongoing budgetary process for the financial year 2025-2026 and the necessity to prioritize key sectors that will drive economic growth, national security, and service delivery in line with the NRM National Strategic Development Agenda, aware that the functions of the NRM Parliamentary Caucus is to consider and adopt a common position on any parliamentary business before the matter is tabled for debate in Parliament, in accordance with Article 35, Clause 5 of the NRM Constitution. Conscious that when a common position has been adopted, members of the NRM Caucus are bound to support the adopted position in Parliament in accordance with Article 36, Clause 6 of the NRM Constitution. Having exhaustively deliberated on the above matters, in light of various testimonies of affected persons and communities, and the historical perspective by the learned Attorney General, among others, do hereby resolve as follows. The proposed amendments to the UPDF Act, as presented by the Honorable Attorney General, with the following broad principles: that misconduct by serving military personnel be tried in the first instance by the military court-martial with the right of appeal through the civilian courts. 2, that civilians who acquire specified firearms illegally be tried by the military court-martial in the first instance with the right of appeal through the civilian courts. 3, that provision be made to provide for right of appeal from decisions of court-martial to civilian courts, implying the court-martials will be subordinate to the civilian court. The final resolution, we received the budgetary priorities for financial year 2025-2026 as presented by the Minister of Finance, Planning and Economic Development, and deferred debate to the next NRM Caucus meeting. Signed, Obua Denis Hamson, MP, Government Chief Whip, Chairperson, NRM Parliamentary Caucus. That marks...
What this means?
The UPDF, for clarity, the UPDF Amendment Bill, when tabled in Parliament, the main sponsor will be the Ministry of Defense and Veterans Affairs. That is why the Minister of Defense is here in person. Yep.
Yes, my question, that's why I wanted this question here. In your experience...
The last one, if I can remember, the answer is yes. I don't know whether that is adequate. The decision of Supreme Court, and I think that can be disposed of with his. Nobody is trying to defeat the decision of Supreme Court. What the Parliamentary Caucus and the government is doing is to conform. Judges make laws. And when they make laws, through advisory or whatever means, we have to make laws that conform to what judges are saying. And that's what the caucus has labored into. So there's no contradiction. So all will be well. They have adopted the general principles, wait for the bill when it will come, how soon. That's a question of time. The bill will come. Yes. That's all I can say. I think about when, that would be very speculative. But whether the bill will come, the answer is in the positive. Have the question, you also have the answers.
Or you want to hear what?
Yes. This would have created appeal to the civilian court.
In their most recent ruling, implying if there existed such a ruling, they have varied it, and the Constitution allows them to vary. So for us, we are going with the most recent ruling where they need an appeal process in the civilian court, and we have provided that. In a nutshell, all these proposals are to comply with the decision of the Supreme Court in its most recent ruling.
How is the second amendment different?
The provision of the law, you say Section 119D of the Police Act or the Uganda People's Defense, when you of the law, no.
Yeah, I thought we are on the same road.
Do you have a copy there you could read?
Actually,
Yes or no?
we don't have that provision now. What you are citing is your own imagination. I think you are citing 117, and what has been quashed, you would be in contempt of the Supreme Court to try to cite.
The second amendment. That's what I was saying.
Parliament is there to make laws. And amendment is one of the processes of how this country can benefit from a legislative agenda of government and of anybody through Parliament. So it would be very unfair of you to get us to discuss the specific clauses of the bill right now, other than the principles as clearly articulated by very able and articulated government chief whip. I think for now, it would be comforting to know that the amendment, the proposals have been adopted. And this, what we have proposed, is to really to conform. Without the Supreme Court, we would not need this caucus. So this caucus is really to give effect to the Supreme Court ruling. And so you wait for the copies, it will come out soon, very, very soon, and then we shall benefit from your insights. But this is a matter that it has gone through comprehensive consultations within the government, and I believe that Parliament will have an opportunity to pick your views as journalists, as civilians, as I think that's how Parliament does.
Yep.
Yeah, so you'll be free, but don't quote Section 117. It was quashed on 31st of January. We don't have it in the laws of Uganda.
The selection of judges.
Oh yes, yes, selection of judges. And I want to thank you for bringing it up for the first time. The first time we have brought out something good. This amendment complies and adopted the proposals by Supreme Court that all the leaders, the chairpersons of those courts martial, will be people qualified to be advocates. And from the advocates, there will be lawyers up to the top. The first one is a unit courts martial, will be presided over by a lawyer, but with others who will act as assessors. This is popular participation at that court level, and even at the division level, advocate and equivalent of who can be appointed the High Court judge, and the General Court Martial will be headed by a lawyer also who can be appointed, who qualifies to be a judge of High Court, with the two other advocates in that who are military officers. So with that one, we've complied 100%. And then on the tenure, the Supreme Court also talked about the tenure, the appointment, the tenure. All that has been thoroughly harmonized. This UPDF amendment will be one of the best legislations that this country will be able to have very soon.
So in the hierarchy, it's where you place this thing.
Apparently, that was not our preoccupation. What we did there was the unit discipline, which used to be a unit disciplinary committee, has been replaced by the unit, this is the lowest, and headed by a person qualified to be an advocate. So if you want to say a court like that could be, you equate it to, not LC1. LC1 is not a court. That would maybe magistrate court, yeah, but it's not in that hierarchy. What we need to know is to appreciate what martial law is. Some of you should be able to read so that you inform this country. What is martial law? What is military law? How is it done in other countries? Is Uganda the only country which is unique with this kind of law? Why? What are the historical aspects of martial law? So that we don't make things that yeah. So there are only three.
For clarity, maybe for clarity.
That's the government chief whip. This is not my media press.
Yes.